Convened of our 151st General Assembly. Mr. Secretary, communications, please.
Madam President, Office of the Governor, Legislative Advisories number 40 and 41. Governor John Carney signed the following
Madam President,
legislation.
Senator Sokola.
May so much be considered the reading of the legislative advisories.
So noted, sir. Mr. Secretary.
Madam President, communications from the House.
Mr. Reading Clerk, kindly read in House Communications.
The House wishes to inform the Senate that it has passed House Bill number 193 with House Amendment 3 and Senate Amendment 1, House Bill number 399 with House Amendment 1, House Amendment 2, and Senate Amendment 1. Senate Substitute number 1 for Senate Bill number 11. Madam President, that concludes the reading of the communications from the House.
Thank you. Mr. Secretary, communications, sir.
President Pro Tempore's list of pre-filed legislation.
Senator Sokola.
Thank you, Madam President. May so much be considered the reading of the pre-file.
So noted, sir. Any additional communications, Mr. Secretary, that have come in?
No more communications at this time, Madam President.
Oh, that's you, Senator Townsend. To you, sir.
Thank you, Madam President. I yield to Senator Sokola for purpose of Senate Concurrent Resolution number 128.
Mr. Reading Clerk, lifted from the, Senator Sokola.
Thank you, Madam President. May we have Senate Concurrent Resolution number 128 lifted from the table and brought before the Senate.
Thank you. Mr. Reading Clerk, kindly read it. Is lifted from the table, Senate Concurrent Resolution number 128.
Senate Concurrent Resolution number 128, sponsored by Senator Sokola, Townsend, Lockman, providing notice of a hearing on and the alleged reasonable cause for the removal under subsection 13 of Article 3 of the Delaware Constitution of Kathleen K. McGuiness, Auditor of Accounts. Madam President, that concludes the reading of Senate Concurrent Resolution number 128 by title only.
Senate Concurrent Resolution 128 before the Senate. Senator Sokola.
Thank you, Madam President. Senate Concurrent Resolution 128 is a very important matter. Auditor of Accounts Kathleen McGuiness was first indicted by a grand jury on 2 felony charges and 3 misdemeanor charges 9 months ago in October of 2021. The first time in Delaware history that a statewide elected official has been charged while in office. Keep in mind that the charges stemmed from more than a dozen whistleblowers from her own office coming forward with reports of the auditor abusing the power of her position for personal and political gain. Each of those charges stand in direct conflict with the auditor's oath of office, as well as the core function of the auditor's office, which is to protect the public's interest, safeguard taxpayer dollars, and ensure sound financial stewardship. While affirming the fundamental right of every accused person to have their day in court, the leadership of this caucus first urged Auditor McGuiness to take a voluntary leave of absence to avoid the conflict of interest that stems from defending yourself against official misconduct while also serving as a watchdog of government finances. Auditor McGuiness refused. In the meantime, the General Assembly, in consultation with one of the most respected state constitutional law experts, sought an advisory opinion from the Delaware Supreme Court regarding its constitutional authority in case Auditor McGuiness had to be removed from office. Finally, after an 8-month legal battle, Auditor McGuiness became the first statewide elected official in Delaware history convicted of a crime while in office. As we stand here today, Auditor McGuiness has had her day in court. And after hearing all of the evidence brought by both the prosecution and the defense, a jury of 12 Kent County residents unanimously agreed that she is guilty of official misconduct, guilty of violating state conflict of interest laws, and guilty of criminal noncompliance with state procurement laws. Any public official who engages in the actions that Auditor McGuiness was found guilty of by a jury is unfit for public office, but especially the state's top financial watchdog. That is why, following her conviction, the leadership of this caucus once again called on the auditor to put the public interest ahead of her own and resign from office. Once again, she did not heed those calls. By refusing to take any accountability for her actions and by actively campaigning for re-election, the auditor has left this body with no choice. So why do we believe this action is necessary? Because although no elected statewide official has ever been removed from office in Delaware history, the framers of the Delaware Constitution were aware this day may come. In fact, they enshrined in our state's foundational document 3 different and distinct methods for removing an elected official from office. Article 15, Section 6 requires the governor to remove from office any public official convicted of misdemeanor in office or any infamous crime. However, case law dictates that the governor must wait for the auditor's conviction to be entered at sentencing, a process that has already taken weeks and could take weeks more. The framers of the Constitution also knew that the executive and legislative branches have separate distinct powers and authority. That is why they granted the General Assembly the power to remove an elected official from office on our own in cases of treason, bribery, or any high crime or misdemeanor through an impeachment process laid out in Article 6, Section 2 of the Constitution. That process, however, must start in the House of Representatives, which would be required to bring charges before the Senate can try the case. We, of course, cannot compel the House to act, but we are not rendered powerless. A third option is also prescribed in the Delaware Constitution. That is the process we are initiating here today. Under Article 3, Section 13 of the Constitution, the legislature, by a petition of 2/3 of the members of each chamber, may request that the governor remove an elected official for any reasonable cause. The Supreme Court advisory opinion indicated we could have pursued this path following the auditor's indictment, but in the interest of due process, we waited. Many in this room believe 2 different grand jury indictments met the standard for reasonable cause. Certainly a jury verdict on multiple crimes, including official misconduct, meets that standard. By passing the resolution before us today, the Delaware State Senate is exercising the powers granted to the legislature by the Constitution to begin removal proceedings for an elected official convicted in a court of law of abusing her office. Should this resolution pass both chambers, the Senate President pro tempore and the Speaker of the House would be authorized to set and communicate a date for a joint session of the General Assembly for a hearing to be held with Auditor McGuiness present to consider petitioning the governor for her removal. This is, by its very nature, due process. It is fully and completely constitutional. It does not preclude the governor from unilaterally exercising Article 15 powers once a judgment of conviction is entered in Superior Court. But this action today moves the process forward in a significant way while the auditor refused to hold herself accountable, continues to serve, and continues to campaign for re-election. And it is my hope that today's vote will make clear to the residents of this state that they can count on their elected officials to step up and stand up to those who abuse the public trust. I stand and wait for comments or questions.
Senator Pettyjohn.
Thank you, Madam President. I rise on behalf of my caucus today in opposition to this resolution. We stand opposed not because of any individual who's named or who's involved in the case before us. We don't stand opposed because we believe the individual accused and named in the resolution did nothing wrong. On the contrary, we stand opposed to the timing of this resolution because this individual, in the eyes of the law, is still innocent. Let me repeat that. This individual, in the eyes of the law, is still innocent. This individual has not been convicted of any crime resulting from an indictment and trial. The conviction has not happened. While Senate Concurrent Resolution 128 artfully dances around the details, details are extremely important. The detail which is missing is likely the most important detail, that while the jury did come back with a verdict of guilty, the judge in this case has not yet ruled on post-trial motions and could in fact acquit the individual of all charges against her. Again, she has not yet been convicted. We firmly believe in the rule of law. We also believe that it's a fundamental right for the presumption of innocence to be maintained until the logical conclusion of a trial has occurred. What we are asking for is not an indefinite delay while appeals on this case are being heard if a conviction is entered. We are merely saying that beginning this process before the judge has entered a verdict and sentenced the individual is too soon. Every person in our state is entitled to due process. Soon, the richest man in the world will be involved in a court case here in Delaware. Our courts also hear from those who are the most destitute on a daily basis. Each of them and everyone in between is entitled to equal protection and due process under the law. Continuing down this path today is a not so gentle erosion of those bedrock principles. Madam President, because this is happening too soon, I'd like to make a motion to table this resolution.
We have before us a motion. Objection has been announced. We will therefore have to take a roll call on the motion to table. Therefore, those listening in, I want to make sure they can hear as well. We have a number listening in. If you are a yes, you are in favor of tabling the resolution. If you are a no in opposition, you stand with the resolution before us. So a yes is to table, and a no is not to table. With that, Mr. Secretary, would you kindly call roll on Senate Concurrent Resolution 128? On the motion to table 128.
Senator Benini? Yes. Senator Brown?
President voting yes.
Yes. Senator Ennis? No. Senator Gay? No. Senator Hansen? No. Senator Hawker? Yes. Senator Lawson? Yes. Senator Lockman? No. Senator Lopez?
Yes.
Yes. Senator Mansavinos? No. Senator McBride? No. Senator Paradee?
No.
No. Senator Pettyjohn? Yes. Senator Pinckney? No. Senator Poore?
No.
No. Senator Richardson?
Yes.
Yes. Senator Secola?
No.
No. Senator Sturgeon? No. Senator Townsend? No. Senator Walsh?
No.
No. Senator Wilson? Absent. Madam President, the roll call reveals 7 yes, 13 no.
Having failed.
1 absent.
Excuse me?
7 yes, 13 no, 1 absent.
1 absent. Having failed to receive the required sufficient vote, the motion is declared failed in the Senate. We still have before us Senate Concurrent Resolution 128. Senator Benini?
Thank you, Madam President. And Madam President, with the President Pro Tem's testimony, is this a 2/3 bill or a straight majority bill? I'm a little.
This is a simple majority bill. It's a Senate Concurrent Resolution.
Okay, so this is not the
No
procedure that
supermajority, no.
that the Senator, okay.
No.
We shouldn't do this. Politics is politics. I didn't vote for this person. I don't know her very well. Maybe had 5 or 6 conversations, enjoyed the conversations. Let me tell you something I do know about her. She was freely and fairly elected. That's what I know about her. As were all of us. Any of our names could be on this resolution. If we're charged with misdemeanors. People in these chambers, by the way, have been charged with misdemeanors, not just this chamber, other chambers. We're going to set the precedent that someone who, by the way, is not guilty yet, maybe even not yet. This is factually wrong. Line 1, was found guilty. Nope. The judge hasn't ruled yet. I get very upset when the government starts picking on people, even if they're political opponents of mine. I've read more about this case than I ever wanted to, trust me. The judge asked the prosecution, I believe it was 6 times. If I'm miscounted, I apologize. Where's the crime? And the jury said, there are no felonies here. And the jury, a couple hours before the 4th of July weekend, said, well, let's do some misdemeanors. I, thank goodness, have never been charged with a misdemeanor. I'm certain I've done things in my life that if you read deep enough into the law books, I probably could have been charged with misdemeanor. I don't think I'm mistaken in this, but if you have enough code violations in your house, you can be charged with a misdemeanor, not just the code violations. We live in a log home. I guarantee you, if somebody spent 2 weeks in our house, they'd find a whole lot of code violations just because it's how the building is constructed. You gonna remove me from office for that? There are people who are gonna remove her from office. And they're gonna have a say in 7 weeks. Your party is gonna have a say in 7 weeks whether she gets to continue to hold office. By the way, people in my party are gonna have that same opportunity for me in my district. And they're the ones who should make the decision. And if you honestly take time to look at this trial and look at the motions, and by the way, I would not be surprised if those charges are dismissed, and you think what happened is worth removing somebody who has been fairly and freely elected, I don't even know what to say. I didn't vote for her. Sorry, Auditor, I'm probably not going to vote for you again if you're on the ballot. I voted for the Republican. I'm a fiscal watchdog. I try to be. Let's just use me. I won't use any of my colleagues here. If I got in a bar fight and it turned into a low misdemeanor, you're going to remove me from office? My guess is probably not. You'd probably take my committees away, you do some more appropriate punishments. This is wrong. The people are going to tell us. I have faith in their judgments. There's an election in 7 weeks where the people in your party will get to pass judgment on her. And if she wins that, in November, there'll be another election where the entire state of Delaware will have an opportunity to pass judgment. Unless you committed a true high crime / felony that really breaks the people's trust, the people, you should always default to what the people decide. And I'm sorry, as you know, I'm very fond of everyone in this chamber. The personal relationships that here mean a lot to me. But one of the things that really bothers me, and not just here, I think in the entire political spectrum of the last several years, we can't live in a place where we use the tools of government against political opponents that we don't like. And that could happen to any of us. I've done a lot of things in this chamber that have made you guys really angry. By the way, some of them you should have been angry. Okay, guilty as charged, right? Do you think the people of Delaware think it would be okay for you to remove me from office because of that? No. The people in my district are going to have an opportunity to do that this year. So please, everybody needs to vote how they need to vote, and I certainly don't mean to cause offense to any of my colleagues here, but I just think we should default to the people. They're going to have an opportunity to tell us what they believe. And folks who are freely and fairly elected to office, whether it's in this building, whether Frank City Council, whether it's a county office, whether it's a statewide office, we need to be very, very suspect of any opportunity to remove them from office unless the people do that. And I just feel very strongly that this is moving in the wrong direction. Especially, and I want to reiterate, she's not guilty yet. Right? Do not be surprised if the judge dismisses those charges. I've read them. She hasn't been sentenced. The law says until you're sentenced, you're not guilty. So we're here starting the process to remove a freely and fairly elected public official based on a crime we think maybe in the next couple of weeks she will be officially convicted of. So and again, I certainly don't mean any offense to any individual members. I just think this is the wrong the wrong way to go. And I think we're setting a very dangerous precedent. Because this could be any of us.
Senator Lawson, then Senator Townsend. Senator Lawson.
Thank you. My long career in law enforcement, I live by the statement that Voltaire made, protect the innocent at all costs. Are we doing that here? Because there's no one guilty yet. We're not doing that. And we swore to uphold the Constitution. Are we doing that? It looks like somebody ticked somebody off. And now we're going to go after them because we don't like what they did or what they were alleged to have done, because they haven't done it by court decision yet. I think we need to slow down, rein it in a little bit, quit being premature, because if this is thrown out by the court, she's found not guilty, we're going to look like less than wise, and I'll leave it at that. I think we could do a better job than this. Jumping out here prematurely is uncalled for, it's unnecessary, and I can tell you the folks see it as political theater. Thank you.
Senator Townsend.
Thank you, Madam President. I think given the gravity of the moment, I do want to make a couple of quick comments in response to our colleagues' thoughts. First, I think it's very important to be as factual as possible with this. Senator Benini pointing out the language of the resolution and saying that the resolution is inaccurate by, on line 1, using the words "was found guilty." Senator Benini, I guess, has chosen not to read the 6 words that follow that, which say "was found guilty by a jury of her peers." So I think it's very important to note the distinction between what Senator Benini has said and what the resolution says. I think it's also important to note the distinction between different stages of these processes that can play out in a court of law. The language of our own Constitution contemplates possible actions and deserved actions at different points in that process. It gives the governor not just the authority, but indeed the mandate to remove someone once sentencing has occurred and a conviction has been entered. Perhaps the reason why it waits until that point to give one individual not just the ability, but the mandate to do it is because only at that point should one individual have such power. But the framers of our Constitution, through multiple conventions, believe that it would be wise to have another path in the Constitution, a path that could be walked before sentencing is completed, because there can be times where it's appropriate to walk that path before sentencing is completed. And perhaps everyone might not agree about that, either generally or in the facts of this matter. But I do think it's important, especially because we took an oath to the Constitution, to be very clear that we are proposing to utilize language that is explicitly in the Constitution, that the Constitution considers that there will be moments where it's appropriate to move forward prior to sentencing occurring, at which point then it's not even a question, because the governor has not just the authority, but indeed the obligation to remove the person from office. I think it's also important to note that removal from office here, as Senator Benini says, it could be any of us, and he points to examples of code violations at one's home, like grass or fences or something, that code violations and misdemeanors more generally are entirely different from misdemeanors that involve breach of public trust and misconduct in office. So if Senator Benini is worried about an unprecedented moment in Delaware of forging accountability for an elected official statewide in particular who's held by a jury to be in violation of the public trust, if that's a worrying precedent, then I'm okay that it's worrying, because that should be the precedent. That should be the standard. Hasn't happened to this point, but doesn't mean it shouldn't be the standard. It means it's the first time that it's happened. I think also Senator Benini referenced the idea that we should wait until there's a moment in which the people's trust has truly been broken. Well, that, I guess, can be up to each individual to decide for himself or herself whether or not a jury, and I'll note a Kent County jury, saying this person is guilty beyond a reasonable doubt after weeks of testimony, this person is guilty. I think there are many people who feel that is a moment in which the public trust, as the breaking of the public trust has occurred, has been validated by a jury beyond a reasonable doubt. If not everyone is there, then not everyone's there. But I can just say, in hearing Senator Benini make his comments, that the idea the public's trust has not been broken already as found by a jury, I respectfully disagree. Senator Benini also talks about, and sort of, I don't know the exact quote, but basically it said we should really wait until the charges are serious enough, and he said until real high crimes. Well, as Justice Randy Holland had advised us many months ago, and as he and others have written, both in Delaware and as other states' precedent clearly shows, these are the kinds of high crimes and misdemeanors that founding generations had thought we should be bearing in mind and should have the tools to address. Again, if someone wants to say it's not a high enough crime for me, someone has the right to say that. But case law and analysis indicates that, in fact, this qualifies as a kind of high crime for which a public officer can and I believe should be removed. Senator Benini said many times the idea that someone is elected through a free and fair election. I do not believe that a free and fair election result creates an absolute shield from accountability, no matter what the conduct is after that election. We cannot just focus on how someone got into office. We must also focus on person's conduct in office. And in this instance, we now can focus on what a jury has said about that person's conduct in office. Senator Benini has said that in the coming weeks, voters in a primary will have their say. Nothing we do today and talk in terms of proposing to initiate a process, and nothing that would occur as a result of this process would change that. Impeachment is the only process by which an elected official would be ineligible for being on the ballot or continuing to serve in office among the three processes in the Constitution. This is not one of them. So this does not change the ability of voters in the coming weeks to make that decision. What this is about is how the Senate feels in response to an unprecedented situation. This resolution, the phase we are at now, post-jury verdict, is not a happy one. It's not a one that I think any one of us wants to be here, but it's the one that we believe has the most fidelity to Delaware's Constitution. In terms of exercising the powers that we have in the Constitution, and I believe, therefore, the obligation that we have in the Constitution to make governing decisions in Delaware. Yes, it's unprecedented. The first time for anything is. And no, it is not a happy moment for anyone. But that does not make it the wrong moment. Applying constitutional language is not unconstitutional. Due process in the criminal context has its avenue, and due process in the constitutional context of a bill of address has its avenue. The two do not conflict. We as a body had asked the Delaware Supreme Court for an advisory opinion on many of the elements that have led to this. We did so in consultation with the late, absolutely great Justice Randy Holland, and we are certain that this passes constitutional muster. We also believe, even if not unanimous, that it also represents the public's expectation of what those in the legislature or other places of governing power will do when a jury has found someone guilty of misconduct in office.
Senator Hocker, followed by Senator Sturgeon. Senator Hocker.
Thank you, Madam President. Very seldom did you see the opposite party of the governor take sides with the governor. He says it's premature to make a decision now, and he was going to wait till after the judge's decision. And that's what this side of the aisle has done. But he has the authority and the obligation to do so once she is convicted or ruled guilty by the governor. And it looks to me that doing this premature today doesn't have faith that our governor is going to do what he feels is the right thing to do.
Senator Townsend, then Senator Sturgeon. I think he wanted to respond to Senator Hawker. Senator Townsend.
Thank you, Madam President. Just to be clear, what the governor said is that this would be premature in terms of him exercising his powers under the Constitution. He did not say what Senator Hawker just attributed to him, that this overall process is premature. It's certainly not what he said publicly or, to my knowledge, what he said to anyone. So his statement was the removal of the unilateral removal of the auditor by the governor would be premature given the language of the Constitution and the requirement that her sentence has to be entered in Superior Court before a single individual should have such authority. That's what the governor said. The governor did not opine on this process here.
Senator Sturgeon.
Thank you, Madam President. Senator Townsend did a very good job of taking point by point the claims or the comments made by Senator Bonini and said similar things to what I would have said. There was only one piece, in my view, missing, and this refers back to both comments made by Senators Bonini and Lawson. The idea that this is politically motivated. So I just wanted to address that. Senator Bonini, you said that you did not vote for Auditor McGuiness, but I did. I did vote for Auditor McGuiness, and I likely would have voted for her again if she hadn't been charged and subsequently found guilty of 3 misdemeanor charges involving her office. So this is not politically motivated. And it is important, this is not a matter of law, but this is a matter of my character, again, being brought into question, that somehow I would take such a serious act and be involved in such a serious process against someone because I somehow disagreed with them politically. Nothing could be further from the truth. I wouldn't do this to a political opponent or to a political friend if I didn't believe that it was my job to hold our own accountable, and if I didn't believe we had the authority and the obligation to do this when we find that someone is no longer fit for office because they have abused the public trust and they have put people who work in that office in untenable positions. So I am going to repeat what I first posted when the charges were brought up. And that is, I was not elected to serve and protect the powerful, but to serve and protect the people who too often are the casualties of misdeeds done by powerful people. I cannot stand by and allow innocent civil servants and our voters to be put in that position. This is not political. This is about doing the right thing.
Senator McBride.
Thank you, Madam President. As others have said, this is a solemn day. We often drive down to Dover with excitement and wonder at the opportunities we have to move policy forward. But today is a sad day. But sadly, it is a necessary day. The foundation of all of the work that we do is built on public trust. And sadly, with both the indictment and the guilty verdict by a jury, the public trust has been broken. We are a small state and we all know one another. It's difficult to do something like this. Whether you've met someone 6 times, whether you've met someone 20 times, whether you consider them a friend. This is a difficult task. But if a small state is worthy of self-government, it is a task that we must proceed with. Senator Townsend said, rightfully, that this situation is unprecedented. Indeed, it is unprecedented in the state of Delaware, as this is the first time a sitting statewide official has been found guilty of a crime by a jury of their peers. But oftentimes when we look at our actions, whether policy or constitutional, we look to other states and the precedents that have been established in other states. In Illinois, in 2009, the former governor of that state was essentially unanimously impeached and removed from office upon his arrest. Prior to even an indictment, certainly prior to being found guilty of any official crimes in office. In Connecticut, The governor of Connecticut resigned facing definite removal from office simply because he was under investigation for crimes within office. In Pennsylvania, when the Pennsylvania Attorney General was charged with corruption in office, the Pennsylvania House voted to begin removal proceedings even before any verdict. The trial concluded, and she was found guilty. She resigned the day after the jury verdict, but months before the sentencing was entered and a conviction was entered by the judge, because she was facing almost definite removal in a legislative procedure following that guilty verdict. The US Congress removed a judge in 1988 after the judge was actually acquitted of crimes in office of public corruption, reinforcing the fundamental truth that the legislative process for removal from office is fundamentally different than a judicial process that results in the loss of liberty. The loss of liberty itself is a birthright. The loss of liberty is determined through a judicial proceeding. The loss of office is not the same thing. Indeed, it is not a birthright. And while other states provide very clear precedent, very clear examples of legislatures proceeding before a conviction is entered, we have to look no further than the language of our own Constitution, as Senator Townsend has alluded to. As Senator Townsend mentioned in response to Senator Hocker's point, we have sort of focused in on this point of conviction because it is relevant in one of the three constitutional avenues for removal. But if that point of determination was relevant in deciding whether we should act in those other two, then it would render those other two constitutional provisions effectively meaningless in instances of public corruption and almost meaningless in almost all serious instances of criminal activity when a person is in public office. The Constitution of the state is clear. Just as a business owner wouldn't be required to maintain employment of someone who has been found guilty by a jury of their peers of stealing from that business, neither does the Delaware Constitution require us to allow for an individual who has even been charged, let alone found guilty by a jury of their peers, continue in office. Indeed, the Constitution provides us an obligation. That obligation is not whataboutism. It's not to engage in baseless conspiracy theories about motivations. It is not an obligation to allow someone else to do our job. The constitutional obligation is to act. Thank you, Madam President.
Senator Sokola. Senator Gay has risen.
Thank you, Madam President. Just because my colleagues have done such a great job, I will let their statement stand, but I did just want to correct some misinformation because I think that it's important for especially those covering in the press who are listening to understand that the members of the General Assembly could not be removed using this Article 13 Section 13 of Article 3. It specifically exempts Lieutenant Governor and the General Assembly, and so it would not be setting a precedent for members of this body. I'd also like to counter and, well, I won't use a stronger word, but I feel very strongly that some of the statements made today undermine our jury system, which is a foundation of our democracy. And I would never place myself in place of a jury of peers. And I do respect the third branch of government and the courts, and I want that statement to be heard today as loudly as the others. So thank you.
Senator Sokola.
If there are no other questions or comments, I'd ask for a roll call.
Mr. Secretary, kindly take roll on Senate Concurrent Resolution 128.
Senator Benini. No. Senator Brown.
No.
No. Senator Ennis. Yes. Senator Gay. Yes. Senator Hansen. Yes. Senator Hocker. Not voting. Senator Lawson. No. Senator Lawson. Senator Lockman. Yes. Senator Lopez.
No.
No. Senator Mansavinos. Yes. Senator McBride?
Yes.
Yes. Senator Paradee?
Yes.
Yes. Yes. Senator Pettyjohn? No. Senator Pinckney? Yes. Senator Poore?
Yes.
Yes. Senator Richardson?
No.
No. Senator Sokola?
Yes.
Yes. Senator Sturgeon? Yes. Senator Townsend? Yes. Senator Walsh?
Yes.
Yes. Senator Wilson? Absent.
Senator Hawker?
Senator Hawker from not voting to no. Madam President, the roll call on Senate Concurrent Resolution number 128, 13 yes, 7 no, and 1 absent.
Having received the required and sufficient number of votes, Senate Concurrent Resolution 128 declare pass the Senate. Senator Townsend.
Thank you, Madam President. I move the Senate stand in recess until the call of the President Pro Tem.
Hearing no objection, the Senate is hereby in recess.